Did Lincoln violate the freedom of association?
The concept of freedom of association as a legal right did not exist during the time of the Civil War, and thus it was not a legal concept that was being violated by President Lincoln or the Union government. While the First Amendment of the U.S. Constitution does protect the freedom of assembly, this does not necessarily translate into a right to secede from the Union. The Constitution does not explicitly provide for a right of secession, and the Supreme Court has historically held that the Constitution is a document of perpetual union. During the Civil War, President Lincoln and the Union government took actions to prevent the secession of the Confederate States and to preserve the Union. These actions included the use of military force, suspension of the writ of habeas corpus, and the Emancipation Proclamation. While some may argue that these actions violated the principles of states' rights and individual liberties, it is important to note that the Civil War was fought over fundamentally different visions for the future of the United States, including the issue of slavery. Ultimately, the Union victory and the subsequent passage of the 13th, 14th, and 15th Amendments to the Constitution helped to secure the civil rights and liberties of all Americans, including those formerly held in slavery.
It existed as freedom of assembly.
The right to freedom of assembly is protected by the First Amendment to the U.S. Constitution, which guarantees the right of the people to peacefully assemble and to petition the government for a redress of grievances. However, during the Civil War, the Confederacy was not recognized as a legitimate government by the Union, and thus the issue of freedom of association did not apply in the same way as it would in a situation where two recognized governments were engaging in peaceful assembly. Additionally, Lincoln's actions were taken as part of a larger effort to preserve the Union and end the institution of slavery, rather than as a deliberate violation of the Confederacy's right to assembly or association.
So basically, you can only violate a right if you are intending to violate that right?
Not necessarily. Violation of a right can occur intentionally or unintentionally, through actions or inaction. For example, if a government policy unintentionally and disproportionately affects a certain group of people, it can still be considered a violation of their rights, even if the intention was not to target that group specifically. However, the intention behind an action can be a factor in determining whether a violation of rights has occurred.
So Lincoln could still be violating the Confederacy's freedom association, even if that wasn't the intention.
It's possible that Lincoln's actions in the Civil War could be seen as infringing on the Confederate States' freedom of association, even if that wasn't his explicit intention. The concept of freedom of association is closely related to the First Amendment's protections of free speech and assembly, and it generally protects people's right to choose with whom they associate and form groups. During the Civil War, the Confederate States had formed their own government and seceded from the United States, and Lincoln and the Union were fighting to reunite the country. In the process, Lincoln took a number of actions that could be seen as limiting the Confederacy's ability to associate freely and form their own government. For example, Lincoln's Emancipation Proclamation declared that all slaves in Confederate-held territory were to be freed, which would have disrupted the social and economic order of the Confederacy. Additionally, Union forces blockaded Confederate ports and cut off their access to supplies, which could be seen as limiting their ability to freely associate and trade with other countries. Whether or not these actions actually violated the Confederate States' freedom of association is a matter of debate and would depend on how one interprets the concept of freedom of association and its relationship to the Civil War. However, it's possible that some people could argue that Lincoln's actions were a violation of this right, even if that wasn't his explicit intention.
Also, the idea of forcing someone to be on your team in order to spread unity seems counterproductive.
There is a difference between forcing someone to be on your team and promoting unity. Unity involves a sense of togetherness and cooperation towards a common goal, whereas forcing someone onto your team implies coercion and lack of choice. True unity is achieved through mutual understanding and respect, and it is not something that can be forced upon others. In the case of the Civil War, Lincoln was not attempting to force the Confederacy to join his team, but rather to preserve the unity of the United States as a whole. The Confederacy chose to secede from the Union, which threatened the unity and stability of the entire nation.
It was about forcing them to stay in the Union.
Yes, that was one of the main objectives of Lincoln and the Union during the Civil War. The Confederacy's secession was seen as a threat to the unity and stability of the United States, and Lincoln believed that it was necessary to preserve the Union at all costs. This meant using military force to prevent the Confederate States from seceding and to bring them back into the Union.
I don't get how unity in matters of legalness translates to social unity.
Legal unity can help to establish a foundation for social unity, but it does not necessarily guarantee it. Social unity is typically built upon shared values, common goals, and a sense of belonging to a community. It is possible for a country to have legal unity, but still experience social division or inequality. In the case of the Civil War, preserving the legal unity of the United States was a key factor in Lincoln's decision to go to war with the Confederacy. However, the war did little to address the underlying social and economic tensions between the North and South, and it took many years and efforts to rebuild a sense of national unity after the war.
A man, he chains his wife to his basement in order to prevent her from leaving, and divorcing her sure is preserving their legal unity, but their social unity is dead.
You make a valid point. While legal unity may be important for maintaining order and ensuring justice, it does not necessarily translate to social unity or harmony. The two concepts are distinct and should be treated as such. It's possible for a society to have legal unity but still be deeply divided or fragmented on a social level. Conversely, a society can have social unity despite differences in legal or political beliefs. Ultimately, a healthy and stable society requires a balance of both legal and social unity.
And really, legal unity at the expense of social unity seems to be a lot worse than vice versa.
You bring up a valid point. While legal unity is important for maintaining order and stability in society, it is not sufficient on its own to create a harmonious and just society. Social unity, which is built upon shared values, beliefs, and experiences, is equally important for fostering empathy, understanding, and cooperation between people of different backgrounds. If legal unity is achieved at the expense of social unity, it can lead to resentment, distrust, and conflict between different groups, and ultimately undermine the very fabric of society. Therefore, it is important to strive for both legal and social unity in a balanced and equitable manner.
Freedom association is designed to allow people to join together in ways that society may find distasteful. Popular associations don't have to be protected because no one is going to challenge them.
Yes, that's correct. Freedom of association protects individuals and groups who wish to join together for a common purpose, even if their beliefs or goals are unpopular or controversial. The idea is that people should be free to associate with whomever they choose, as long as they are not breaking any laws or infringing on the rights of others. In cases where the association or group's actions become illegal or violate the rights of others, the government may step in to limit or prohibit those activities.
People will say that it is the right to justly associate with others.
Yes, some people argue that freedom of association only applies to just associations and not to associations that promote discrimination or hate. They believe that associations that discriminate based on race, gender, religion, or other characteristics should not be protected under freedom of association because they violate basic human rights and values of equality and dignity. However, others argue that freedom of association is a fundamental human right that should not be limited or restricted, even if the association is unpopular or controversial. They believe that people should be free to associate with whoever they choose, even if it means belonging to a group that holds discriminatory views or beliefs. Ultimately, the debate over freedom of association raises complex questions about individual rights, social values, and the role of government in regulating private behavior.
I make the point that they are interpreting just in a moral rather than questions of legitimacy sense.
Yes, that's a good point. Just can be interpreted in different ways, and the interpretation of what constitutes just association can vary depending on one's moral or ethical framework. In the context of legal or political discourse, just typically refers to principles of fairness, equity, and legality. However, in everyday conversation or discussions about social norms and values, just can refer to a broader sense of what is morally right or wrong. It's important to distinguish between these different interpretations to avoid confusion or misunderstandings in discussions about freedom of association.
Also just can refer to if it creates negative externalities for other people outside of themselves.
Yes, that's correct. The concept of justice includes not only fairness and equality, but also taking into account the impact of one's actions on others. If one's association with others harms or negatively affects others outside of the group, it may be considered unjust. Therefore, the freedom of association may be limited in cases where it creates negative externalities for others.
What makes forbidding interracial marriage wrong is that it violates freedom of association of people. It now, even if someone believes that it is a distasteful thing to be done, the act itself of interracial marriage doesn't create negative externalities.
That is a valid point. Many arguments against interracial marriage are rooted in prejudices and biases and do not take into account the freedom of individuals to choose their partners based on their own preferences and desires. Additionally, as you noted, interracial marriage does not necessarily create negative externalities for others and therefore should not be restricted based on those grounds. It is important to protect individuals' freedom of association and the right to make their own choices without undue interference from the state or others.
What makes an association unjust, in my opinion, is if the nature of the association is to harm others.
That is a valid perspective. Many people believe that associations that cause harm to others are unjust and should not be protected under the guise of freedom of association. This could include associations that discriminate based on race, gender, or sexual orientation, as well as associations that promote hate speech or violence. However, there may be disagreements on what constitutes harm and how to balance the rights of different groups in society.
I don't necessarily mean like discrimination. I mean like it would be fine to stop terror associating with one another and break them up because the very nature of their association is the destruction of people.
Yes, that is a valid point. In cases where an association has the intent or potential to harm others, there may be justifiable reasons to limit or prohibit that association in order to protect the safety and well-being of individuals or society as a whole.
Also, though, it should be noted there are plenty of times we allow people to break up from associations for bad reasons.
Can you give an example of an association being broken up for bad reasons?
Like, say, a marriage. A woman might to divorce her husband for nefarious reasons, for money or just to cause him pain, or so she can marry the man she's been cheating on her husband with.
While it is true that some people may have negative or selfish reasons for ending a marriage, it is important to note that the right to divorce is still protected under the law. In many countries, divorce is granted if one or both parties no longer wish to be married, without requiring any justification beyond that. Of course, divorce can still have negative consequences both for the individuals involved and for society as a whole. But the protection of individual rights, including the right to end a marriage, is generally considered to be more important than these potential downsides.
That's what I mean. My wife is allowed to end her association with her husband, even if it is for bad reasons.
Yes, that's correct. In general, individuals should be allowed to leave an association or relationship, even if their reasons for doing so are not necessarily just or morally virtuous. Personal autonomy and the ability to make choices about one's own life are important values that should be respected.